call from a seller really concerned because the seller's broker was telling them that they had to leave the property in order for it to be shown. And the seller admitted to the Attorney General's office that they were experiencing COVID symptoms. So really freaked out about having to leave at all. The AG's office reached out to us to see if we had any jurisdiction to deal with that. And as the listing agent, there's a couple things that we could look at. So based on the Attorney General's advice, executive orders like these are enforceable like a law. So as you guys, I'm sure, are aware, under your brokerage duties, whether you're a single agent or a transaction broker, you're not allowed to violate the law in the performance of your duties. So that was one way that we could look at a broker trying to force somebody out of their house for a showing. Also, it could be potentially perceived as unworthy and incompetent practice because you're putting the public at risk, especially if they have COVID symptoms and you're making them leave or have contact with others. So we had encouraged the Attorney General's office to actually have that gentleman file a complaint with us so that we could investigate it. We never actually received that complaint. I know that the Attorney General's office has been sending out a lot of letters because they've been getting a lot of real estate related complaints about brokers showing properties. So the Attorney General's office is able to interpret an executive order. The division does not. So you're not going to get any clarification from us on any type of public health order or an executive order issued by the governor, because that's just not our place. But what we were trying to do was deal with the interpretations coming out of the Attorney General's office. And at one point, because they were getting so many different complaints in, we had volunteered to send out some guidance to our licensees, because we'd rather have everybody on the same page about what you can or cannot do, versus it just being managed through kind of these nasty grams from the Attorney General's office telling you that you're violating a public health order and the criminal penalties associated with doing that. So that was really kind of the genesis for us to release the guidance that we did about a month ago. And we've been just kind of dealing with the complaints that have come in. We do actually have 4 COVID-related complaints against real estate brokers that we've assigned for investigation, and that was due to brokers blatantly disregarding the health orders. The other ones, we've got a handful of complaints right now kind of in our queue of brokers that seem to be oblivious that they couldn't be out and showing properties. So we had initially decided that we would just send out kind of a letter saying, hey, you don't get to do this right now. But since we're now at the safer at home order at the state level, you are able to go out and do showings. Just bear in mind that there are restrictions. So this is not by any means business as usual. You're still having to do social distancing. If you're going into a third party's residence, you have to wear mask and gloves. You have to sanitize frequently touched surfaces. And I don't know who gets to be the lucky person that is doing the sanitizing. I don't know if that's a listing broker or the buyer's agent. And you're also supposed to be inquiring before you go into a third party property whether anybody in that property is exhibiting symptoms of COVID or has been in contact with anybody that has tested positive for COVID. So this should be an interesting nuance, because I don't know how many people are willing to offer up health information at this point. But just bear in mind, there's a website. It's www.coloradosaferathome.com. And this was information that I believe was compiled by the Colorado Department of Public Health and Environment. We were not involved in the guidance that they've issued, but they do have some guidance specific to, they call them field services and real estate. Particularly with real estate, what is pulled out is you don't get to do any open houses. You also need to make sure that none of your gatherings are 10 people or more. I don't know how many people have that many individuals on a showing. And then the other thing that they pointed out for the real estate industry is that you can't have any food or beverage available at showings, which I think they were a little confused. That's something you would do at an open house rather than a showing. But you are now able to go out and do showings. Just also be cognizant of what county you're in, because the county itself may prohibit you from being able to do those showings. Like I said, Boulder We're still under a stay-at-home order, as is Denver, Jefferson County, Adams. Douglas is not. So for the brokers that practice in multiple locations, that's going to be something that's kind of speaks to geographic competency at this point. I did get asked last week by Scott Peterson and also Damian Cox about how would we deal with complaints coming in for brokers, you know, under the safer at home orders that are not complying with the county restrictions. And I don't know how we're going to deal with that. I really don't want to have to go into the minutia. I would rather we just kind of look at what the state order is, because that's the broader order across the entire state. But I don't know what is in store for us as far as complaints are concerned, because we have been getting quite a few complaints about brokers violating those orders, and I don't think that they're going to stop now that we've kind of relaxed some of the restrictions. So that is what we have been dealing with as far as COVID is concerned. There has been an extension on license expirations, and this really just only applies to the real estate brokers because you guys are still, some of you still have those anniversary dates, so they've just been extended. And then with continuing education, for the people, the providers that had gotten approval for in-court or in-classroom instruction, we have basically exempted them from the online requirements in the interim, just because they did have their courses approved. And this is an optimal time for you guys to do online learning, since you're not really going to be out and about very much. The other thing to be aware of is if you have anybody looking to come into the industry, one of the big things that is going on right now is the testing centers are closed. I think PSI is going to be looking at opening up a few testing centers, and they're going to have to deal with social distancing and everything else related to that. And for mortgage loan originators, they're trying to figure out a fix at the federal level. They may be doing online proctoring. And then PSI also manages our appraiser examinations as well. So we're not seeing a whole lot of new applications coming in these days, just because nobody can take any of their exams. I think we had about 7 in the queue last week, and we're kind of noticing a dip in our numbers by about 250 new licenses per month. So hopefully once the testing centers open up, we'll start to see kind of an uptick in our license volume or license application volume. But other than that, we're all telecommuting at this point, but we're still doing investigations. We're still issuing applications for those people that do have their exams. It's just pretty much business as usual. We're still approving continuing education. We're still doing CE audits. So I'll just kind of give you guys an idea of what we have going on, so that you have an idea of what to expect from us. We are going to do rulemaking for the Real Estate Commission in July or June. Time is relative these days. I can't even remember what day of the week it is. So in June, we've already filed this rule. We're going to clean up some of the accounting rules. One of the big issues that we have been hearing about with the brokers lately is a lot of you do not just do licensed real estate brokerage activities. You do other things on the side, like maybe short-term rentals, you do Airbnb. What you need to be aware of, though, is anytime that you take money belonging to others, whether it's real estate related or not, based on the state statute, you are required to comply with the Real Estate Commission's accounting requirements. So if you're doing short-term rentals and you're collecting deposits, the requirement is that that deposit gets placed in a trust account, and also that you're doing three-way reconciliations. One of the things that we're going to be addressing with the rulemaking is try to make, basically making that message more clear. But one of the big problems right now is the accounting rules require that the trust accounts be in the name of the employing broker. And your employing broker may not want to be on a trust account that you have for Airbnb deposits. So we are cleaning up that language, and that's what the rules will do in June. But just bear that in mind. Anything, even if you had a house painting business on the side and you collected deposits, based on the state law, that deposit has to be placed in a trust account, and you have accounting requirements, the three-way reconciliations. So keep that in mind. Another thing that we're working on is, so the Forms Committee has been working on a manufactured housing contract, and hopefully we will have that available for you come January 1st. I know they're trying to hammer out some details about FHA and VA lending requirements for manufactured housing. But this has come about due to the change that resulted from the Real Estate Commission's sunset review a few years ago, when they kind of expanded the definition of what a standard form is. And they included in there that you can do a personal property agreement in conjunction with a real estate transaction. So as I went out and spoke to brokers after that law changed, I heard a lot of brokers saying, oh, great, well, I'll use that personal property agreement for manufactured housing. And that's not what that agreement was created for. That agreement was created mainly for your mountain communities where you've got second homes being sold. And in conjunction with the real estate transfer, they're negotiating the exchange of artwork, furnishings, snowmobiles, you name it. So that's what the personal property agreement was meant for. And because we've heard so much from the real estate brokers that they need a manufactured housing contract, that's what the Forms Committee is working on. They also have been working on cleaning up the post-closing occupancy agreement. They had discussed about revising the earnest money receipt. I don't know if they're going to get around to that. They're kind of focused primarily on the manufactured housing contract. That, and we don't know what is in store for us when the legislature convenes, because they've been kind of put on pause. And you never know how reactionary they're going to be following this pandemic about just different legislation that may impact the real estate industry, particularly as far as our contracts are concerned. On the note of legislation, so last year they did a sunset review of the HOA Information and Resource Center. That report was released on October 15th. The actual analysis itself is done by a policy analyst that works for the Office of Policy Research and Regulatory Reform, which is located within the Department of Regulatory Agencies, but it's separate from the division. So they make independent recommendations. They came out with 2 recommendations for the HOA office. The first was to continue the office, and the second recommendation was to create a dispute resolution program within the Division of Real Estate. And it's modeled off of a mobile home park program that is housed within the Department of Local Affairs. That program is not up and running yet, and it has not demonstrated any success. So we potentially could be chartering uncharted territories with this recommendation if it makes it through the legislature. There are a couple bills dealing with HOAs that were moving through the legislature before COVID happened. One was the HOA sunset bill, and the other was to adopt some recommendations that we had made to the governor as a result of his executive order that he issued last year following the veto of the Community Association Manager Licensing Bill. So with the dispute resolution program, one of the concerns that we've had is basically just the workload to deal with that. We kind of anticipated that to deal with all of the complaints that would come in about HOAs, it could potentially double the size of the division, and that doubling would all be for the HOA office. We're also concerned about just the sheer expense of it, because based on the stakeholder process that we dealt with, most people don't like their HOAs. And so we're going to be the first stop for them to grind their axe with their HOA. This program is set up to not really function quite like our licensing programs. So when you file a complaint with us, and it's about a real estate broker, if we do the investigation and we find that there was wrongdoing, the commission makes a decision and they can discipline the broker, and the broker can either accept the discipline that the commission wants to render, or they can go through a hearing process. What was proposed with the HOA office was that the division would do an investigation, we would issue findings, and then basically, I think anybody that doesn't like the findings could then take it through a hearing process. It wouldn't just be the affected person. So I anticipate that if the program makes it through the legislature as they kind of conceived it, this is going to be really expensive as far as litigation is concerned, and it's just going to, I don't know that we're ever going to get cases resolved. They're just going to be kind of stuck in the morass of the court system. So we'd had some concerns, and then also who's going to pay for this program. Um, it could become really expensive to live in an HOA in order to fund this program itself. So that is the one HOA bill that we are dealing with. The other bill, so last year the industry had run a bill to try to resurrect community association manager licensing. They really did not include the division, and we had several issues with it. And there was one day where there were 19 different amendments introduced in the legislature for this bill, and one of them was finally the straw that broke the camel's back, because it was going to strip any funding of that program for about the first year. And if a program doesn't have funding, the program doesn't run. There's nothing that we can do for it. So all along, we'd voiced concerns with that bill. Finally, we got to go over and tell the Senate what our concerns were. And the Senate was nice enough to listen, and they ended up doing a strike below on that bill and just kind of resurrecting the program as it previously existed, but they only gave it a 1-year continuation date. So anticipating that there would be more legislation this year for community association manager licensing. We anticipated that that would have been signed into law, but we kept getting inquiries from the governor's office about, well, what are the real issues with HOAs and community association managers? And it's really hard to justify a licensing program when you look at the bulk of our complaints, and 97% of the complaints that we investigated in the prior year were all dismissals. I think we only had 6 disciplinary cases. So you can't justify having a licensing program and passing on the expense of having to meet all the thresholds to get that license when you have only 3% of your cases resulting in discipline. So the governor decided to veto it, and instead he issued an executive order directing the Department of Regulatory Agencies and the Division of Real Estate to engage stakeholders and look at 4 different areas. Basically, one of them was he wanted us to re-examine the Community Association Manager's Sunset Review and see if the recommendations were still pertinent. He wanted us to look at transparency issues in general with HOAs, transparency issues with HOA fees and with community association managers. And then the 4th category was he wanted us to look at the body of law and see if there was basically a way that we could recommend some modifications to make the law easier for consumers to use. So we did 4 separate meetings to address each of those topic areas. I always compare it to going to Walmart, because when you go to Walmart, you can always find somebody that looks like they're having a worse go of it than you are, and that was those meetings. I'm really glad I don't live in an HOA. Following the 4 meetings, what we did was we put together some recommendations, and those went over to the governor's office. So there's a bill currently going through the legislature that would basically adopt some of those recommendations. There were some minor tweaks made. I think at this point, though, both of those bills, they're looking at revising them just because of some of the industry outpouring of concern, particularly with the HOA Sunset Review, about the sheer cost of that program. So I would expect that when the legislature resumes, you're going to see some changes to those bills happen pretty quickly. Other than that, I think that's the only legislation that we're really tracking. There was one bill that was introduced earlier by the Bankers Association, and that was to broaden the exemption from appraiser licensure so that bank representatives could be included in the exemption. That has passed, and I believe the governor has signed that into law. But other than that, I think for the most part, HOAs is the one that is keeping us on our toes these days. There are a couple things that you need to be aware of that we do on a regular basis, and they're compliance related. And it was kind of like the perfect storm this past month or so. So at the beginning of every year, we usually start in February and it continues through March. We do errors and omissions insurance audits of all of our brokers. You got to have an active errors and omissions insurance policy in order to have an active license. So we go through and we audit you guys. This year has been the most promising. I only think we knocked down 300 brokers this year for not having errors and omissions insurance. So if you don't have an active policy, we will switch you to inactive, and you can't practice until you have an active policy. Previous years, it was kind of par for the course. We would have 3,300 brokers that we would have to inactivate because of no errors and omissions insurance. I would tell you though, that even though we only had 300 go down this year, a good practice for you to do is anytime you're going to go to a closing, I would go onto our system and make sure that the broker sitting across the table from you has an active license, because if they don't have an active license, they shouldn't be sitting at that closing. And on that note, so there's basically 5 different license statuses that we have. Active is the only one that you can do license duties under. Inactive usually means that you've decided you're not going to practice for a while. You don't want to have to deal with the errors and omissions insurance requirements or the continuing education requirements. Then you've got expired, which means you've let your license lapse and you've gone into expired status. The thing about an expired license is you have 3 years from the date of expiration in which you can reinstate your license. The longer you wait, the more expensive it gets. So that first year, you're basically just paying, I believe it's 1.5 times the renewal fee if you go beyond that, those first 30 days. After that, you're basically paying double the renewal fee when you go into years 2 and 3. And it doesn't extend out then your expiration date. So if I am in year 3 of my license being expired and I wait until October to reinstate it, I'm going to pay double that renewal fee, and then 2 months later, I'm going to have to renew it again. So just be careful about letting your license lapse. Then you've got suspended, which usually people are suspended because they did something really bad and the real estate commission has decided to penalize them and give them a cessation of practice. Although sometimes we see people be suspended because they didn't pay child support. And so child support enforcement will send over a data feed that will knock people down, and we have no control over it if you don't pay your child support. Usually, if we catch somebody that's practicing with a suspended license because they've had a disciplinary action from the real estate commission, if you continue to practice, that's usually the commission just decides that, okay, so you've blown them off, now they're just going to revoke your license. Child support enforcement, they don't necessarily revoke. I've only seen one broker have a complaint filed because their license was suspended due to child support non-payment. The commission did end up disciplining their license, but they didn't revoke them. Then the final status is revoked. And that is when the commission has said, we don't want you practicing anymore. You do a horrible job at it. And if you continue to practice after you've been revoked, then probably what we're going to do is we're going to seek an injunction from a court of competent jurisdiction. And I'll tell you, the real estate commission doesn't like to be ignored. If you want to continue practicing after a judge has issued an injunction, then you're probably going to be facing contempt of court because judges really do not like to be ignored. So just keep that in mind. If you go into our system and you search somebody and they show up as expired, suspended, revoked, those people should not be practicing real estate. I think the real estate commission is a little more forgiving if they're on inactive status because we can quickly bring you into compliance. And ultimately, that's our goal, is if you're inactive and you want to practice real estate brokerage, we just need to make sure that you meet all the criteria to go back to being active. So we either want to bring you into compliance with the license law or we want you to stop practicing. So the other thing that we do that is compliance related is continuing education audits. And we audit about 10% of our active population annually. We do quarterly audits. And the thing that you need to keep in mind is a 3-year license requires 24 hours of CE, 12 of which has to be the annual commission update course. You can't complete the same annual commission update course more than once for credit, although I don't know why you would want to complete more than one of them. I find them kind of painful myself, but and then the other 12 hours are elective credit. And just make sure that when you are signing up for CE, you go on the division's website to make sure that the course that you're going to take has been approved. Because we have quite a few brokers that when we go out and do the CE audits, they'll produce the CE certificates thinking that everything has been approved by us, and then they have this horrible epiphany when we reach out and say, no, your courses haven't been approved. and then you get fined for CE noncompliance. So definitely make sure you're checking your classes. For those of you in a transitional license cycle, which means we are moving you from an anniversary date over to a December 31st date, so you don't have a full 3 years of licensure, what you need to know is you still have to do 24 hours of CE. You only have to do 2 annual commission update courses though. So the additional 4 hours is just elective credit, and that's all you have to worry about. So those are the 2 compliance issues that we typically deal with on a regular basis. And next, I'll just move on to the common complaints that we see. So I'm not aware of this being a big issue in Summit County. I know it is in the Denver metro area, but we have a lot of brokers that are just giving out lockbox combinations to their buyers. They're not going to the property with them, and they're just allowing the buyer to go in and view the property. So prior to January 1st, if you were doing this, what the commission would do is deem you to be unworthy and incompetent, which I'm sure everybody loves to be called that. And you would get, typically the first violation is a $500 fine. I do not know what the commission will do on a second violation because fortunately we haven't had any repeat offenders yet. We do now have, as of January 1st, we do have a rule specific about property access. So this covers this lockbox scenario. So it's still, after January 1st, it's still a $500 fine for the first time out of the gate. But definitely do not just give somebody a lockbox and let them have access to the property. And the rule itself is actually broader than just buyers. It talks about any third-party access. So basically, if you're going to give somebody third-party access, if I was the buyer's agent, I have to have the listing agent's permission to do that. So it applies to appraisers, home inspectors, it could be radon mitigation people, you name it. So just keep that in mind as well. Another common complaint that we get is disclosure of material facts, conflicts of interest, and affiliated business arrangements. So material facts, it's not whether you think it's important or not, it's whether the consumer thinks it's important or not. So you as a broker need to disclose, and let that consumer make a decision on whether it's important to them. And having worked for the division as long as I have, you know, if I was to leave tomorrow and go back to practicing real estate, I would be making sure to basically follow up, probably in writing via email, reminding my consumer, hey, I told you that this was an issue with the property. Please confirm that you don't have a problem with it. So probably not a bad idea because that at least gives you some evidence of the disclosure should they file a complaint with us. And they do file a lot of complaints with us about disclosure of material facts. Conflicts of interest come up both with sales and property management transactions. We see it quite a bit in property management where I, as a broker, refer my landlord over to my husband's maintenance company. That is something that needs to be disclosed in writing so that they are aware that there is a conflict of interest there. We also see it in sales when people are basically representing family members. So if you're going to represent your son in a purchase transaction, you need to be disclosing, you know, my son is related to me, the licensed broker. Affiliated business arrangements only apply to settlement transactions. So we don't expect to see affiliated business arrangement disclosures for property management because those aren't settlement transactions. And what you need to keep in mind with an affiliated business arrangement is if you have 1% or more direct or indirect ownership interest in affiliated business arrangement, that is something that you've got to disclose to the consumer and also to us at the division. You'll disclose it to us anytime you acquire or get rid of an affiliated business arrangement, or when you go from inactive to active status and you're going to have an affiliated business arrangement. And then employing brokers are required to make the disclosure annually. You'll do it with a consumer before contracting. And it's kind of goofy how they set this law up because all parties to the transaction have to sign off on this affiliated business arrangement disclosure, which I say it's goofy because, I mean, if I'm going to refer my buyer over to my husband's mortgage company, why should the seller care that the mortgage broker and the real estate broker are related or that there's an ownership interest there? But that is currently how Colorado law requires it. So just keep that in mind. We don't see too many affiliated business arrangement complaints down at the division. The next category of complaints that we see, you would think would be a no-brainer, but it just continues. There is an expectation after you get licensed that you don't go out and commit crimes. So if you're found guilty, plead guilty, or plead no contest to, there's like a litany of criminal offenses. By virtue of the conviction or the plea of guilt, that gives the Real Estate Commission authority to discipline your license. And not all crimes are created equally. A lot of people seem to think that it's just felonies. There are misdemeanors included as well. The commission typically looks at the circumstances underlying the criminal conviction or guilty plea, and they're basically trying to make an assessment of whether it's real estate related or not. If it's real estate related, they're usually a little more harsh with the discipline than they are on the non-real estate related offenses. So if you're in a bar fight and you get convicted of third-degree assault, the commission may fine you, but it's probably not going to cost you your license, unless you're in a bar fight with your real estate client, and then they may see that a little differently, and you may get something more than a fine. Some of the more kind of colorful criminal convictions that we've seen is we had a broker out of Beaver Creek that burglarized his own listing and stole a very unique leather coat from it. Then he wears the leather coat down to the police department to get fingerprinted for his real estate broker's license when we were doing fingerprinting at time of renewal, which helped Beaver Creek solve their burglary case really quickly. And he not only got to be fingerprinted for us, but also for his criminal case. And then we also had one that was out of the, I believe it's got to be out of the Denver area, because this man hired an undercover Denver police officer to kill his wife, which, while not real estate related, that is something that we look at as far as, well, if that's what you're going to do to somebody that you love, we do not want to see what you will do to somebody who might stiff you of a commission. So that gentleman is not licensed with us anymore. Neither is the burglarizing broker. Property management generates a third of the complaints that we receive down at the division. A lot of what we deal with as far as consumer complaints really has to deal with managing their expectations. They seem to they don't understand that property managers basically aren't going to just go into the property unannounced and make sure that the property is in pristine condition. We get a lot of complaints about normal wear and tear. We get security deposit disputes. Those are kind of the vein of the consumer complaints that we get. But also know that we're out there actively doing brokerage audits, particularly of property management, because this is one of our biggest areas of potential consumer harm, just because of the amount of monies that property managers hold. So when we are out and about doing the audits, typically what we're seeing these days are real estate brokers not doing three-way reconciliations. We're also seeing the issue, like I described earlier, about the short-term rentals where the brokers are not putting those funds into trust accounts. The accounts are not properly named. And then also what we have been seeing lately is that the brokers think they have trust accounts, but actually when you kind of dig a little deeper with the banks have just labeled them a trust account, but they don't actually have the fiduciary nature of a trust account. So if you hold trust accounts, definitely make sure that your bank hasn't just named it a trust account, but that it actually is one. I think we're only aware of about 5 banks in the state right now that offer the trust accounts that comply with the Real Estate Commission's rules. So practicing without an active license is something that we see pretty regularly. And if you do encounter somebody where you have looked them up on our website and you find out that they are practicing and they've got an inactive license, or they're suspended or revoked or not licensed at all, please file a complaint with us so that we can deal with that. And bear in mind, you can file anonymous complaints. So just make sure that you're very detailed, because we're not going to have the luxury of being able to follow up with you to get additional information. But that is something that a lot of our licensees don't realize, is you can file an anonymous complaint. Broker supervision is an issue that we see quite often. So what you guys need to be aware of is anytime somebody files a consumer complaint with us, based on commission regulations, when we get that complaint in, not only do we review it to see if we have jurisdiction, but during the course of the investigation, one of the things that the investigator is going to be looking at is whether there appears to be a lack of supervision. And if there was a lack of supervision, we will then open up a complaint against the employing broker and do an investigation on them. I have seen the real estate commission. We've had, like, I think it was last June, we had quite a few employing broker complaints. There seems to kind of be trends in our complaints as we work through them. But I think June was the month where we had the heavy amount of employing broker complaints. And I have seen the real estate commission, to discipline an employing broker, they will actually lower your license level so that you can't manage other brokers and make you requalify under the new experience criteria. So that is something to keep in mind as well. They can also make you take the brokerage administration course again too. Teams has been an issue, largely having to deal with unlicensed people and also advertising. So a lot of the complaints that we get are that teams use certain terms that they're prohibited from using, like real estate or realty, where they actually appear to be their own little brokerage within the larger brokerage. There's a reason that we have prohibited you from using those terms, and that's because we don't want the consumers to be confused. If you want to advertise as the Waters team, you can advertise as the Waters team, but you can't advertise as Waters Realty Team because basically there's a concern that the consumer then thinks that that's a company of its own. And I've heard a lot of complaints about team leaders allowing unlicensed people to do licensed brokerage duties, but you can't allow an unlicensed person to do licensed duties. And this is another case where supervision may come into play as well. We may not just open up on the team leader allowing it, but we will also open up on the employing broker who's supposed to be supervising that team leader. And there's a reason that we've limited teams just to one licensed brokerage. So I could not team up, if I worked for Coldwell Banker, I could not team up with a broker from RE/MAX and create a team. And the reason that we restricted that has to do specifically with supervision, because we did not want to have two employing brokers pointing the finger at each other over who was supposed to be supervising what. So we've confined it to just one brokerage. Another issue that we have seen, and we've seen this largely when we go out and do the brokerage audits, has to do with attorney drafted forms. So as a result of the sunset review a couple years ago, the definition of a standard form was broadened. You can use attorney drafted contracts when they're appropriate to the transaction. Bear in mind, if there's a commission approved form available and it's pertinent to the transaction, that is what you have to use. But you can use attorney drafted contracts. And a prime example of this is going to be your property management agreements or your leases. If you have an attorney drafted form, it's got to have the name of the attorney on it. And the other thing that you need to be aware of is it has to be drafted by a licensed Colorado attorney. So what we have seen quite a bit when you're dealing with the larger franchises is you've got attorney drafted forms, but they typically don't have the attorney's name on them. And then we find out, well, yeah, it was drafted by an attorney, but it was an attorney from California. So that's a license law violation in and of itself too. I haven't seen the Real Estate Commission penalize anybody significantly for that. The big thing is that you're not drafting your own contracts, because that's the unauthorized practice of law. And while the commission doesn't have the authority to deem that you have committed UPL, basically what they can do is they can deem you to be unworthy and incompetent because you were practicing beyond your level of licensure. And I know a question popped up about the advertising rules. Since all of our rules have changed, it basically rendered me of having, I don't remember the rule numbers anymore. So I will send Sarah the number for the advertising rule so that you guys all have that. It's frustrating anymore these days because they changed all of our statute numbers, and then we went through and did the rule review, and as of January 1st, like all of us that have been at the division for a long time, it's like they've rendered us senseless. Nobody can remember anything at this point. So I'm constantly having to go back to the manual, but I'll email the advertising rule. And then lastly, the other thing that we continue to see, is Colorado law does not support the business model of entry-only brokers. So if your business model is to collect a fee to just put a property in the MLS and that's all you're going to do, that is not allowable under Colorado law. Basically, what it amounts to is one of the duties that requires a real estate broker's license is the advertising of property for sale or lease or exchange on behalf of another. And when you're performing those license duties, you can practice in one of two capacities. You're either a single agent or a transaction broker. And you've got to perform all of the duties for whichever one you're going to be. So you don't get to separate those out. And we actually now have a case that has worked through the system supporting the commission's position on that. So, and it's in the annual update course this year. So that is pretty much it for the common complaint types. I will give you kind of an idea of where we are at with our population numbers. We currently have, and these, I think these numbers may be a little old, like by a couple months. We have about 48,424 licensed real estate brokers in Colorado. We've got 2,994 credentialed appraisers. And then we have 13,768 mortgage loan originators. The real estate brokers are our biggest program and they keep us the most busy. You guys are by far the most creative group of licensees that we have. I know I have to read all of the investigative reports for all the different programs. And I start off with the real estate brokers first because those are pretty entertaining. Mortgage loan originators, we don't have too many complaints against them, but they are kind of cut from the same cloth as the real estate brokers. They're entertaining as well. And then the appraiser complaints are really dry and not very exciting at all, but that's not a bad thing. So with that, do you guys have questions for me?
Okay, great. Thank you. That was great information. And I love that there's been a consistency. Scott Peterson and Damian Cox called realtors very creative as well. So that's a skill realtors must need to have. Okay, let's go and look at the questions. Is there a date that short-term property managers are required to submit the previous month's income back to an owner by law? I had a client ask me this. I thought it was around the 20th of the next month, but can't find it in the real estate manual. If there's a date, would a rental management contract override this?
So I'm not aware of any regulation about those, but I think this is another area where you guys are really having to deal with local ordinances in addition to whatever state laws may come into play. And also keep in mind, I mean, short-term rentals are really outside of the commission's jurisdiction. What pulls them into the commission's jurisdiction is when a licensed broker is doing them, because you're held to a higher standard than the public.
Okay, cool. I think you've already answered this one, but is it possible to sit for a test to get a new license? The National Association of Realtors is trying to calculate that for states because they are aware that this is an issue for new members.
Yeah, not current. So currently you can't take a test. The first part of May is when they may be looking at opening up some of the testing centers. And I think they're just trying to figure out how they can safely deal with that.
Perfect. Okay. And like you said, you don't really manage short-term rentals, but the question is, as a managing broker for a short-term property management company that has just begun long-term rentals and real estate sales, does my responsibility include the short-term rental deposits? I believe I heard that you are working to adjust that responsibility in June.
So currently the responsibility does fall on the employing broker. We're going to try to parse it out come June. And it won't just be short-term rentals. It will also be brokers with their own investment properties, because when you take that security deposit, those are tenant funds. So those have to go into a trust account as well. So currently, that money would also be the responsibility of the employing brokers. So we're going to try to parse it out when you're doing kind of side business and your own investment properties, so that those are not falling on the employing broker.
Okay. All right. And then on advertising, we get a lot of questions at SAR about advertising. I know you're going to send me those an email with that stuff, but is there a place on the website to get it that you know of easily?
So chapter 2 of the manual, so when you guys go in and look at the rules, they look a lot different than they used to. They used to be in alphabetical chapters. Now they're in numerical chapters. Chapter 1 is a common set of definitions, and then they go through. Chapter 5 is the accounting regulations, and chapter 6 are the professional standards. So the advertising rule will be in chapter 6.
Okay. Our parent company is located in Utah. It is a nationally recognized property management company. We will be using their forms for the long-term program. Is this okay?
So you're going to have to work with a Colorado attorney who will basically kind of take on the responsibility of kind of having their name associated with that form and reviewing it, making sure that it complies with Colorado law.
Great.
I know one of the questions that has come up as we've gone out and done the brokerage audit. So this has been a big issue, and this was part of what kind of triggered the whole discussion about needing to change what the standard form definition is. Because when we go out and deal with the property managers, we have a lot of brokers that are doing creative drafting, and they're creating their own leases and property management agreements, which you don't get to do unless you're licensed as an attorney. So one of the questions that has come up within the past 6 months, and I think it was actually December of last year, was, well, what if I draft it as the broker and then I just have a licensed Colorado attorney review it and kind of bless it? And the commission has said that that is unacceptable. So just make sure that you're dealing with a form that has been drafted by a Colorado attorney, or, you know, if it's the case of a Utah attorney has drafted it, but a Colorado attorney has gone through and doesn't have any issues with it and doesn't have a problem putting their name on that document, that probably would be acceptable.
Okay. All right. Can a team use a name that is already in use by a brokerage? Example, I'm registered with the CREC and Secretary of State as Dream Big, Colorado. I started getting online complaints thinking I was using a team using the same name.
So you don't get to use a name that's identical to an already licensed entity.
Okay. All right. Where can we find and download the additional requirements for showings? I will send that out to the members. We're hoping to put together an infographic for our members on the Summit County rules compared to the state rules. And then we'll also do the same for Park County and Lake County as well. I've had requests for all. So we'll have that in the next couple days for you.
And we sent out an email blast last night that has a link to those Safer at Home guidance. So you can go just find that email and go to the link through there.
Yeah, and I'll forward that out to you all too. It's super helpful. When selling a unit that has existing bookings, can the listing broker steer the seller to cancel bookings that the buyer expected to be on the books to then rebook with a partnered company?
You've stumped me on that one.
Okay.
Well, I mean, if the buyer was already aware that they were going to have these bookings, I don't think it demonstrates good faith for the seller's broker to try to discourage them to get rid of those bookings, because the buyer is anticipating that they're going to have that income stream. I think you could run into a legal issue where attorneys become involved if you do that.
Should it be reported to the commission?
That is probably something that we would look into, as far as just kind of, you know, good faith and potentially dishonest dealing.
Okay. All right, let's see. That's all the questions on there. Let's go into these. Can a resident of Boulder or any other county still under a stay-at-home order come to Summit County to look at real estate?
That's a good question.
So
I'm not really sure.
So Summit County has not, this is not formalized, I don't think, in the official way, but they are highly encouraging people to not come to Summit County. but they understand. I know I've had these conversations with our county commissioners. I know that they understand that right now during the month of May, with all of our lodging being shut down, that there is no place for them to stay here. So they understand that there are going to be day trips with these new rules allowing showings.
That scenario might be a good one for the broker to do a virtual tour.
Mhm. That's excellent. Yeah.
I mean, really, the goal is to limit contact as much as you can so that this thing basically can be placed under control and you're not exposing a bunch of people to the virus.
Yeah, exactly. Okay, let's see. If we have consulting income, but it's not a deposit, it's payment for services, that doesn't need to be in a trust account, right?
Correct. That's
Okay,
income.
okay, cool. We're getting down to the nitty gritty. All right. Um, my understanding of the accounting requirements and trust account rules were if you are managing other people's money, for example, managing a rental, rent and deposits, etc., for a client versus managing your own rental property, if a broker is just managing their own personal properties, long or short-term rentals, do they still need to follow these accounting rules?
So, well, when you're managing your own properties, you're going to be collecting security deposits. So those are going to be required to go into a trust account, but you would not put your rental income into a trust account.
Okay. Let's see. My license is scheduled to renew May 11th of 20. Did I hear Marcia say that the date may have been extended?
So it's interesting. A couple weeks ago, they had followed up with us because if you expired during April, we had basically moved your expiration back by 30 days. And they had brought it up at the department level a couple weeks ago about us doing that through May. I'm not aware of the governor issuing a new order, but that was basically the plan, is that we were just going to extend even the May renewals out as well.
Okay.
But bear in mind, you also have the beauty of our licensing system is you can go online without having to interact with human beings and renew your license.
Okay, good. Are brokers allowed to perform brokerage services for a real estate firm where their license is not hanging?
No, you can only practice where your license is hung.
Perfect. What is now the proper procedure and form to convey personal property such as furniture in a real estate transaction? Hold on, they texted me. Hold on. Let me start over. What is now the proper procedure and form to convey personal property such as furniture in a real estate transaction, especially one with a federally guaranteed loan?
So we now have a commission approved personal property agreement. So that is the form that you would be using.
Okay, great. Can you talk a little bit more about issues that you've had with DRs? Sarah's talked about doing kind of a DR designee program for raising the expertise and the competency of a DR. What are some of the issues that you see with them?
Okay, first, what is a DR?
Oh. Designated realtor, employing broker.
Okay.
Yeah.
So, okay, can you give me your question again?
Okay, sure. So when you talk about employing broker complaints that you've had, what are some of those complaints?
You know, so we have some employing brokers that do a really awesome job about being available. The expectation is the employing brokers are our first line of defense, and they are there to make sure that license law violations don't occur or reoccur. But they also have to be available to answer questions. They need to be reviewing the transaction files. So we have some that do an awesome job at those duties. And then we have others that really just exist as an employing broker to collect a fee, and they provide no supervision. And one of those that is like a stellar example of how not to manage brokers, he was collecting a $500 fee for each transaction, and the two brokers underneath him were rampantly committing mortgage fraud. So with that complaint, none of those three are licensed anymore. So a lot of the time, we'll find out that they've delegated their supervision down to somebody else. And I will tell you, you can do that. You've got to do it in writing. But you also, it doesn't absolve you from the responsibility. So if you delegate down to somebody who's doing a poor job at supervising, we can still open up against the employing broker, and the commission can discipline the employing broker's license. So whoever you're going to delegate your responsibilities to, I would make sure that they are competent to do those duties. A lot of the other things that we've seen as far as employing brokers are concerned is they haven't been reviewing the transaction files. They have no idea what their broker associates are doing. And that's, I mean, those are kind of the fundamentals of being a supervising broker.
That's great feedback. All right. Let's see, what other questions do we have? We got a few more here. Okay. Oh, okay. A comment is highly discouraged for people coming in and out of the county to look at property. Some second homeowners can come if there is a compelling reason, for example, repairs. If a seller is not truthful on his seller's property disclosure and it's not obvious why, or could we be liable for his misconduct?
So we get quite a few of these complaints where right out of the gate, they just assume that the broker should have known something. And it's pretty typical when we go through and do the investigation that the broker actually had no knowledge of the issues with the property, that it's a seller issue. So the real estate commission doesn't hold brokers responsible for when sellers are lying to you. You don't have an independent duty to inspect the property. So you're basically having to go on whatever information you get from the seller, or also whatever you find out during the course of the inspection. So no, I don't think, if it's obviously obvious that the seller was lying to you and you had no way of knowing, we wouldn't discipline your license.
Okay, great. All right, last question. Thank you for clarifying that deposits for our personal rental properties need to be in a trust account. Does that trust account need to be in the employing broker's name? Currently, we have lots of agents who are managing only their own properties. Are you saying we are supposed to have a company trust account where all of those deposits are held, or can each agent have their own trust account?
So under the current regulations, the expectation is the trust account has to be in the name of the employing broker, even when you've got a broker associate that has investment properties of their own that they're managing. But that is the rule change that we're looking at doing in June, so that the employing broker doesn't have to have that responsibility.
Cool. All right, last question, because we're almost out of time here. Oh, we've got a couple more questions. Hold on. Is it appropriate for the broker's knowledge of the disclosure items to be on the SPD, i.e. the items that broker knows, or where should the broker put those items?
Well, so since the seller's property disclosure is completed by the seller, I wouldn't expect anything from the broker being put on there. But I definitely, if you were aware of something that the seller has either omitted or is trying to conceal, you definitely have to be disclosing that. And I would cover my end and do it in writing.
Excellent. Okay, last question. I recently passed on a listing that the seller did not want to disclose noise issues between units. Are noise issues something we should disclose? The listing agent did not disclose it when my client originally purchased it. So
I would say yes, at least from our perspective. I don't know how that would shake out if you litigated it, but I mean, a noise issue is going to affect somebody's enjoyment of that property potentially. And so if you've got somebody who doesn't care about the noise, then they can make that decision, but I would still disclose it.
All right, cool. Excellent. Marcia, this has been extraordinarily helpful on so many different levels, and we really appreciate your time. We know you're super busy, so thank you very much.
Well, thanks for having me.
Yeah, and if we'll send out to you the Safer at Home email with the latest guidelines from the state on the public order, and again, the local responsibilities that you have, as well as the advertising rules. And then I just want to mention one more time that tomorrow we've got a great class with Jack Laurent teaching on what happens when buyers are ready to come back and purchase, and what does financing look like for them. It's a 1-hour class. definitely worth your time. It's a 1 CE elective credit for the Summit Area Specialist designee. Then finally, I'm going to announce to this group, however many people we have left, 76 people, that tomorrow we are going to be sending out a ballot to the members for, drumroll please, SAR is going to change our name. We would like your approval to change our name from the Summit Association of Realtors to Summit Realtors. And that is because we want to take the focus from the association out and focus on you, the realtor. So look for that ballot, and we hope to have your approval. So thank you all. Thanks for your time. And thanks again, Marcia. We appreciate it. Have a great afternoon.